home today.
Okay, we go wrong.
Okay, my name is Denise Wells and I'm Chair of the Seattle Civil Service Commission, and I'm calling this meeting to order at 2:04 p.m. We're holding this meeting in a hybrid in-person and online format. The public can attend in person or watch online. This meeting is being recorded. For commissioners and staff and others participating in the meeting, I ask that one person speak at a time. If you are participating remotely, please ensure that you mute yourself while others are speaking. For participants, when you speak, please state your name, and it's important that you only one person speak at a time. This is to ensure the record of proceedings is clear and understandable. The agenda is posted on the Civil Service Commission's website, and we will proceed according to the agenda once it's approved. But first, I will read the land acknowledgement of the City of Seattle Civil Service Commission, as well as introducing meeting attendees. We acknowledge that we are in the traditional land of the Duwamish people. We honor the land itself and pay our respects with gratitude to Duwamish people, both past and present. Let us take a moment to reflect on the history of this land, the contributions of the Duwamish people, and the importance of reconciliation and respect for Indigenous communities. This acknowledgement aligns with CSC's commitment to its guiding principles and values of integrity, equity, and accessibility for all. I've already introduced myself. With the rest of the meeting attendees, please introduce themselves, starting with the commissioners.
Ray Caesar, Civil Service Commissioner.
I'm Steve Swell, Civil Service Commissioner.
I'm Andrea Sheely, I'm the Executive Director.
I'm Bill Levin, I'm legal counsel for the commission.
Teresa Jacobs, Executive Assistant. And we have remotely Sarah Butler, our Operations and Policy Advisor.
Thank you. We have a quorum, so we'll proceed to the adoption of the meeting agenda. Is there a motion to adopt the agenda?
I'm gonna make the motion to adopt the agenda.
I second.
All in favor? Aye. Meeting agenda has been adopted. Teresa, is there any public comment today?
There was none in writing or in person.
Okay, thank you. Next, we're going to do the approval of the minutes for May 14th, 2026. Does anyone have any comments or changes to the meeting minutes of last month?
I do not have any comment.
Is there a motion to approve the minutes?
I move to approve the minutes.
And I'll second.
All in favor? Aye. The minutes from May 14th meeting are 2026 are approved. So next item on the agenda are updates and discussion, and the first part of that is the executive director budget and departmental updates by Andrea.
Thank you. You'll find your updated budget related material on page 3. This is as of June 9th, 2026. This is a really high level view of our budget and spending to date, along with our encumbrances. You'll note that we are about, at this point when this was printed, about 56% of our yearly budget has been spent, which is pretty much exactly where we would expect it to be at this time. We had a couple of large invoices get paid related to the firefighter oral boards, and I don't know whether this was printed before or after, but I am confident that we will be within our spending, our allocated budget on spending for the year. So, which is good, where you want to be. As for the budget process, you know, I can't share very much because of the deliberative process, but we have been working with the CBO analyst. I submitted our proposed budget productions on June 9th. And I can't say very much about them, but and I can't say anything. I can't predict the future about what the mayor's proposed budget will be or what the city council will eventually pass. But I do know that it is important for both of those bodies that the civil service department be able to continue to do its work in 2027 and beyond. So it's been a really collaborative process so far, and I expect that it will be until we until the final budget is passed. Along with the budget, Sarah and Joe and another attorney in the law department and I have been working on another piece of legislation that does not have a financial impact, but we are putting it through the process with the budget, as I think is fairly typical for, it's kind of an administrative piece of legislation. What it would do if passed is give the Civil Service Department an official name, which it does not have in the code already. And it would be the Civil Service Department. The reason for doing this is something that we've wanted to do for a couple of years, is it causes some confusion. There's multiple acronyms used for this department in different places. CSC, Civ, we sometimes see PSCSC come up as the acronym for our department. So this will unify, we're already unified, but administratively this will unify all of us under one acronym and one name, the Civil Service Department. The other thing that it will do is a little bit more than administrative, but it will act, and it's related to elections, which are also coming up this year. This will pass in next year's budget, so it won't apply unless it is passed. But it would require that the people who run for elected commissioner have completed their initial probationary period. So the first one you complete when you are hired into a civil service position. So that a person who is subject to probationary separation or maybe subject to probationary separation is not also running for commissioner and serving as a commissioner. This is another one that Sarah and I in the city clerk's office have been talking about for a couple of years. And I think it makes sense. Running an election is a very costly endeavor for the city clerk's office. Luckily, they bear the cost of that. But it costs about $30,000 to $50,000 every time we do an election. That may be for both public safety and civil service, so maybe it's half as much if you're just doing it for one agency, for one commission. But it would avoid that cost, and I think I know that it would give some certainty and stability to the commission to have someone who's not potentially subject to, probationary separation, which is easier than for cause separation, when someone is a regular employee in the civil service. Happy to take any questions on that. Yes.
I'm just curious, have you ever had, I think it's a great idea.
Yeah.
And have you ever had somebody who's probationary?
We have.
Okay.
Yeah, actually, I'm sure it's happened multiple times, but in the election that Ray Caesar won, there was a probationary employee running. They did not garner as many votes as Ray, obviously. But we wondered, I didn't know this person at all, obviously have no idea what kind of employee they were doing. They were for the city of Seattle. But yeah, we consider the possibility. And, civil service has been around a long time, so I'm guessing it's happened before. So it seemed like the time to do it. And since we were, it's kind of a nice bundle of legislation. And then the final piece, and Sarah, feel free to chime in if I miss a chunk of this, is to kind of bring the parts of the code related to the civil service commissions and the civil service department into line with the rest of the code. This is the kind of cleanup that the code reviser prefers to do whenever legislation is being passed. For example, to make language or to make pronouns and language gender neutral, certain formatting changes to standardize the code. Joe or Sarah, anything else that you can think of that we've put into that proposed ordinance that I'm not mentioning here?
Well, this is without opening up too much of a can of worms, with anytime you do legislation to revise the municipal code, there's always a question of how far to go, how extensive to be. So we try to keep it very focused on the main concern here, which was the change, the department name, and some of the issues that Andrew mentioned. But in doing so, there were some inconsistencies that didn't make sense between chapter 404, which is civil service, and 408, which is public safety civil service. So we recommend a few changes in that regard to align them, because those for some topics there's good reason to have differences, but for a lot of others there's not. And so took that opportunity to offer some changes in that regard as well, with the idea to trying to focus on not creating too much a situation where council members would be concerned, and then having the perfect getting away the good kind of situation where then it becomes something that's more expensive than it needs to be. So I think we struck a good balance
Mhm.
there. That's just to say too, that potentially in the future, we could consider,
I thought I had my.
but in the future, potentially you could consider other changes to the code, if those make sense. We'll be talking later about some rule changes. Maybe some of those would also necessitate, or at least have us consider seeking changes to the code, the municipal code. So it's something that's all to say that this is, it's part of the budget process, so it's a good opportunity to do this, but also doesn't foreclose the commission from the future from making suggesting to the council additional changes that you want to make.
I have one more question.
Mhm.
I know probationary employees are not covered by the unions, but do you expect any union pushback on that change? Because obviously somebody who completes probation would then become potentially unionized employee.
Well, I can't speak, I don't know, are new employees not protected by the union?
No, I think they are.
I was not aware of that, but
My recollection from HRI was that probationary employees did not have union protection.
Hmm.
I could be wrong, but that's my recollection.
But they could file grievance, can't they?
Yeah, I would think they, because they're probationary, they still have to union because they pay union dues.
yeah, they don't have the cause protection.
Yeah, that's what I'm looking at, maybe the cause protection, yeah, that's what I'm looking at, but they pay union dues. So if
Right.
I want to file a grievance, it won't look good because you're probationary.
Yeah.
You at will,
And there's a lot of kind of
6
grievances
months.
you could file under the contracts.
yeah,
So what's your question, Steve? Do you expect pushback?
If, assuming a probationary employee then becomes a regular status employee, and the city union making an argument, this person is, well, 11 months in, by the time they're elected, they'll be regular status. So just saying, I could see the union is potentially putting up a fight.
Yeah, well, on the legislation, we better circulate it to the unions, actually.
That's a good point.
Yeah, maybe, hadn't thought of it, actually, thank you for raising that, something to think about. I think, I mean, I'm just thinking off the cuff here in real time, but I would still probably say that it was advisable to have them complete their probationary period by the time the filing date begins, because once the election's begun, you know, people are voting, if a person were to become probationarily separated, the effect would be the same, you'd still have to run another election. But it's something to think about. Thank you, this is a good discussion. All right, other updates for our department, we have come to almost the end of our biggest body of work, our busiest time of year is between January and usually the end of June, or sometimes into July. But we've come to the end of that, and most of the promotional and the big firefighter entry-level exam have been administered. They're in scoring mode now, kind of in rest and restore period for some of our staff who've been working a ton of overtime since before January, actually. So that's very nice. We also wanted to get all of our administrations done early this year because of FIFA and the large hotel and other travel costs that we pay on behalf of assessors. So that's really nice. And we're getting to turn to some of our other work. Of course, the three of us who are frequently in this meeting, we're not administering it. Oh, we do help with administration, but that's not our primary body of work. But it's nice to see our staff members and colleagues getting a little bit of a rest. Otherwise, you know, we are continuing to process appeals. We get a lot of requests for reinstatement from public safety civil service members or former ones. Just continuing to do our work with all of the city department partners and budget, as I mentioned. So I don't have any huge updates for our departmental work other than that. Sarah, do you want to, is there anything else to say about the election? I feel like we kind of filled this group in last time about the timeline.
No, I'm just working on outreach currently. And then things kick off more in September. Communications start going out from the clerk's office, and filing is in October, and then November is the election itself.
Thank you. Why don't we head into item number 6A3 and Sarah, give us an update on CSC rule revisions.
Yes, so CSC rules in the middle of, closer towards the end of getting kind of a first draft scoping document out. If you'll remember, a lot of this was kicked off by the Office of Hearing Examiner Director, making some suggestions that will sync up both of our departments' rules together better. In the course of reviewing it, though, I'm finding a lot of opportunities to make these stronger rules and to bring them into 2026 in terms of how we do work now. I had initially wanted to bring this in front of the commission for consideration in August, but I've shifted it to September. So that's where we are currently.
Thanks, Sarah. All right, if it's okay with you commissioners, I'll move on to the key status report and appeal updates.
Sure.
All right. The case status report is on page 4 of your materials. And I'll go down the line. Case number 2607021A is Hecht v. Parks. You have some materials, there's no action item today on the Hecht matter, but you do have some materials, including his initial appeal and documents related to the step 3 and grievance processes there. Mr. Hecht, so one of the letters has something we don't do very often. I actually did a disclosure to the parties in the Hecht matter related to the doctrine of appearance of fairness. Although I believe that I can be objective and fair and apply the rules as they are written to the threshold review, the threshold determination about whether Mr. Hecht's appeal is within the jurisdiction of the Civil Service Commission. I did want to give them both the opportunity to know that I used to work with and have a friendship with Mr. Hecht's attorney. I've never spoken with her about this matter, of course. And gave them till yesterday, I believe it was, to object or ask any questions that they wanted to ask. We didn't hear from either of the party. So now we will go ahead and review. I have reviewed the materials, but now we'll go ahead and make a decision. And that will be, we will notify the parties of that determination. It's more of a determination than a decision about jurisdictional issues, timeliness, and jurisdiction. The next matter on your key status report is 260109019A, Russell v. SGU. You also have materials in your packet. I think they're ahead of the Hecht materials for Craig Russell v. SGU. And forgive me, but we did plug in the disciplinary decision, which we missed, and I have already circulated to the parties and Department of Human Resources. So now they have it too. But they are the ones who provided it to us, so both parties already have that material. The Russell, so there is an action item which we'll come to after I give you my case status update on Russell and LaCondra. But Mr. Russell did file a timely appeal with the commission. He did exhaust the grievance process. He does have standing with the Civil Service Commission to bring his appeal. He's a regular employee in the civil service. And the action appeal, which is a disciplinary suspension, is in the jurisdiction of the Civil Service Commission. I dismissed the wage theft allegation because the commission does not have the authority to hear alleged violation of wage theft. I would like Just to clarify though, he's certainly welcome if he wishes to do so, or his counsel wishes to do so, to argue that that was part of the decision. If he feels that that's the case, he's not prohibited from speaking about the facts related to that allegation. The parties have been notified, and we'll get to an action item related to Russell in a little bit. Oh, and I'm sorry, I meant to say this at the top of my talking about appeals. And you may know this, so bear with me if you do. When an appellant files their notice of appeal with the commission, they very often, as both of these folks did, send us a lot of material. And it's very reasonable that they would think to do so because they don't know what's coming or what we really need. So what we do is we review those materials, we pull out the things like what you see here in the packet, the discipline decision if there is one, the grievance related materials, and that is what we do our assessment from. The rest of the materials may become evidence in the case later, or they may not, depending on decisions made by the parties. And if the matter goes to hearing and those pieces of material documentation become evidence, you all or the other decision maker will have an opportunity to review them, assess them, and give them appropriate weight. So I just want to make that clear on the record for you all, but also for anyone who may be listening to this meeting, that it's just not time yet to review, for the commissioners to review all of those materials. But rest assured, we have reviewed all of the materials in our review and taken them into consideration for the questions we are asking at this point in the case.
Question.
Yes.
The materials that for each case that's been presented is a standard what is provided to the commissioners,
I wish that we could develop a really clear, crisp list of the materials that we need the employees to submit or the appellants to submit. Unfortunately, I don't think that that's possible. We definitely can improve the list that we request, and we were just talking about that today. Let's time to review what we do need as part of the appeal. The law only, I'm going to try not to get too in the weeds here, but the law requires them just to submit a notice of appeal. It doesn't even have to be on our form. They can just email us at the very simplest. They can just email us, I want to appeal. And we say, well, you got to tell us what you want to appeal. But that's pretty much all they have to give us. We then work with the parties if we need to and ask, do you have a ladder mill letter? Departments call them different things is the other thing. They might call it a disciplinary letter or a post ladder mill letter. Or if they're not a union member, it might be called something different because ladder mill is applying to union members. So we kind of have to do a little bit of detective work, a little bit of legwork sometimes to get materials from employees. There's also sometimes the situation, not in either of these cases, but sometimes the employee's been separated and they don't have copies of the documents anymore. And so sometimes we'll have to reach out to their former employee department and say, do you have a copy of X, Y, and Z thing? So it's a little bit, it can be a little bit more work and we're very happy to do it. But that's why we will either get, that's one of the reasons why we might get not all the documents we need or more documents than we need. And, people have different approaches too, right? Some people are like, let me give you the kitchen sink. And some people are like, they'll ask me if they need it. So we try to meet all of our appellants and employees where they're at and just kind of work with them and explain, if they don't understand what we're asking for, we try to explain it as best we can so that we eventually get everything we need to set this up for your consideration.
So just to make sure I'm understanding what you're saying, based on the question I asked you earlier this week, these exhibits that are here, you wouldn't have needed to, but I don't know whether you received or not. You didn't receive them. I'm assuming based on what you're saying is you really didn't need to see them either to make a determination about whether or not this particular case would fit under the civil service jurisdiction. Like
The short answer is yes.
It's like the investigation report in particular. You really don't
Exactly.
see that yet.
That's exactly
You
right.
can see it. I mean, maybe they sent it, maybe they didn't, but it doesn't really matter. You don't really need to see it to make a determination of whether or not this case
Yes.
is okay.
Yes. Yeah. The grievance, we do need to see that.
Right,
And I'm
right.
good with that.
Yeah, just to make sure that they the full grievance process.
Completely right.
But I asked it, earlier in the week, like, where's the investigation, these attachments? And so she explained to me why she didn't include them, because we don't really need to see them yet until later, if we decide to hear the case.
That's right.
But as an example, so on page 4 of your packet, that blue sheet that has the summary, there's on the files open, there's four matters listed. One from 521, one from 517, one from 423, and one from 5. So for today's packet, the materials for the most recent ones are in there. But previously, you already, the previous packets included the other materials. So those materials aren't provided every single time in the packets because they were already provided previously.
Right.
That's right.
Yeah. So our practice is to provide information related to new appeals that have been reviewed. And yeah, Joe's right. For instance, La Cambra's materials for 2606-015P, his second matter, those were included in a previous packet, and they may be included in a future packet too.
If there's a new decision to make or something else to, action.
Precisely. All right. So with regard to Russell, yes, the parties were notified that his suspension is properly before the commission. It was timely within the jurisdiction, and he exhausted his administrative remedies. I think I already said I did dismiss the wage claim, but he can talk about that certainly. And we told him if he wished to pursue that with the Office for Civil Rights, that they would be the ones to contact. That's my update on Russell. And then La Cambra is still under investigation. Yeah, that is the second La Cambra matter, 2606-015P.
And again, that was somewhat unique because the commission doesn't do a lot of political patronage appeals.
It's the first one since I've been the executive director, the only one.
So you're still reviewing whether or not it qualifies as political patronage?
Right. The rules set forth what is political patronage. So we have given both the it's sort of the complainant, Mr. La Cambra, and the respondent department an opportunity to provide additional information about the facts that he's alleged were violated the political patronage law and rule.
And then you decide whether or not it's.
We are writing up a recommendation for the commission.
Okay.
And the rule says that we make a recommendation to the commission about whether it shall have conduct a hearing on the matter.
Okay.
So that recommendation, we're writing it up and we will give it to you, and then you will get to make a decision about whether or not to hold a hearing on the matter.
Okay. Got it. Thank you.
You're welcome. All right. So if you're ready to proceed to the action item, I'd be happy to say a few words about that.
You want to go with Franklin?
Yeah, no, anything on Franklin?
Oh, I'm sorry. There is no update on Franklin. It is with the Office of Hearing Examiner.
Yeah, I'm ready to move to action items. So I reviewed the material received. You Ray, and you guys need to review materials before we take an action and vote on them. This case.
We're talking about with Teresa, I reviewed it.
Okay, right. You too.
Yeah, Commissioner.
So the action that we're being asked is to decide whether or not we are going to retain or delegate this case to the hearing examiner. So we are going to vote on that now. And if we go ahead.
May I just want to seek legal counsel for a second. Just to put it out there to be transparent, I know Kimberly Leving was the one who did the step 3. I used to report directly to Kimberly. I've not spoken to her since I left the city 3 years ago. We left on good terms, especially want to be very transparent about that. Just to make sure there's no concern about me voting now.
Yeah, so the doctrine that would apply is the appearance of fairness doctrine. So if you feel like you can be impartial, then yes, you can vote on it. If you feel like there's a question about that or you can't, then you should recuse yourself.
I feel good about it, so just wanted to get it out there.
Thank you. That's important.
Can I also state that prior to a hearing, if you send out the list of witnesses to commissioners, they do a conflicts check as well. Great, thank you.
And so as chair, is there, in terms of this action item, it seemed like you were going to explain it some more before the commission considers it, or do you feel like we have enough information, or
Yeah, I can say a few words about it.
for
So-
the record to have a little more explanation of it?
Yeah, so the Russell matter is a disciplinary appeal. He definitely is gonna make multiple arguments, but we know that it is within the jurisdiction of the Civil Service Commission. It is my recommendation that if you all have the capacity and the interest to hear an appeal, that you do consider retaining this appeal and conducting a hearing. And let me tell you a little bit what I do and what you do. If you see fit, I will, as executive director, handle the pre-hearing phases. Well, first I meet with the parties, Teresa and I meet with the parties and explain how the hearing is gonna work. I said before that we try to meet all of our appellants where they're at, and that's true for every phase of an appeal. So we give them lots of opportunity to communicate with us, and we do this with both of the parties, of course, in the room. Tell them what an appeal is, explain to them if they need to know what discovery is, and we always encourage the parties also to mediate their conflict. And set out a timeline for what discovery is going to look like and what tools they have available to them to do discovery. It is not explicit in the rules, but in the past with the Commission, the Public Safety Civil Service Commission, it's more explicit in the Public Safety Civil Service rules. They've delegated responsibility to me to make pre-hearing decisions, rulings, to manage the case as the presiding officer. When it is a question, they've even delegated to me dispositive motions in a case, although you all, Civil Service Commission, can retain decision-making over dispositive matters if you'd like, if they come up pre-hearing. And then when the case is ready for hearing, which will be months from now, if you do retain Russell, it will still take probably at least 6 months to get to the hearing date. Usually based on the availability of the parties and commissioners.
And do you think employees understand that?
I tell them that at the pre-hearing conference, but I don't know what they understand before we get there. So I and our Teresa and Sarah and I will manage that part of the appeal for you. And eventually you will have a hearing. Since it is a 3-day suspension, I expect it would be at least a full day hearing, if not more than 1 day. But we kind of suss that out at the pre-hearing conference to see what the parties, which will be the city of Seattle, will be one of the parties, and then Mr. Russell, for instance, would be necessary with the number of witnesses they plan to call at the exhibit they plan to use.
So do I request then a motion to vote on whether we should retain this case for a hearing?
Should I can make a motion? Are you asking us to make a motion?
Yes.
Okay, just make it clear. I will make a motion that we vote on whether to retain this matter.
Is there a second?
Second.
Okay, all in favor to retain the case of Russell versus SPU-CSC?
Sure, well, just to clarify, was the way you stated the motion was to,
Okay, did we hear the?
yeah, did you
Okay.
consider it? So
Okay,
is the motion rather to retain or not to retain? Is that what you're?
Or a motion to conduct the hearing in this matter.
Okay, I'll rephrase it.
So you can strike your previous motion or,
I will strike the previous motion and clarify.
okay,
I'm making a motion that the commissioners hear Mr. Russell's concerns.
appeal.
You second? Okay. So all in favor?
Aye.
Aye. So the motion passes. You want me to say more? The motion, name of the motion?
Brady, did you vote?
Yes.
Oh,
You,
okay, that's good.
Okay.
And just, in terms of process going forward, I think part of this may have been on the agenda because you had a previous matter where you did vote to delegate, so that's a choice that the commission has.
Right,
But the default would be is if you don't vote to delegate, you're retaining it.
That's
right. I was a little confused
Yeah.
about how to do the motion too, because it said or delegate, so
Yeah.
I think that.
Yeah, so just in the future, you wouldn't have to take this, if you're going to retain it, so the default would be you're gonna retain it.
Right.
That's, but if you do want to delegate, then you can, and you would have to take action to delegate.
Yeah, that's right. And my thinking about putting it on the agenda is, this is the only time I get to talk to the three of you at one time. And so, and if you're, you don't have to take action, as Joe said, but if you're gonna keep it, you might as well vote on it, so it's very clear on the record. So, thank you.
Thank you. Okay, the next, we don't have an executive session this time, so the next item is any old business or new business.
I think it would be good to have a discussion and consider whether or not to conduct the July 9, 2026 meeting. I know that Commissioner Zwerin will be out of town and not available. So we will still have a quorum. Teresa is also not going to be available, and of course, she's not part of the quorum or the commission, but she does facilitate us hearing the matter.
Yeah.
There could be decisions to be made. I think Sarah, you and I discussed that we'll, due to both of our vacation schedules, we will probably not have the recommendation ready for La Combra by that date.
Probably
So-
not.
Teresa or Sarah, do either of you know when the date of the August meeting?
13th.
Thank you, Sarah.
Do you have any huge concerns about us canceling the July meeting?
No, I mean, if the commission doesn't have a business to conduct on that, it has to be done on that date, and certainly cancel a meeting.
I would recommend to cancel the July meeting because of the things that we've discussed, or that I discussed.
And it's not uncommon for the commission to cancel one or more of its summertime meetings, just get vacation schedules and otherwise, for example, Public Safety Service Commission just canceled their July meeting because similar, one of the commissioners couldn't be there and it's summertime and there's wasn't any business that was absolutely necessary for that next meeting. So if you had business that had to get done, but it sounds like there's not.
Nothing that has to get done.
All right, well, I'm fine with that. If anyone wants to make a motion to cancel July meeting.
Sure, I'll make a motion. Thank you. I move to cancel the July 9th meeting.
And all in favor? Aye, so the motion to cancel July 9th meeting is passed.
Thank you.
And I think that is it for our meeting. Unless anyone else has anything else to do the order.
I did not.
Nope, okay.
Thank you all.
Yay.
What do you want to say the time?
Oh, the time is 3:42. 2:42, I'm sorry, 2:42.
Just say we're adjourned.
We got the, and a lot.
Oh, there, thank you. We're adjourned at 2:42. Thank you.
All right. You want to do the again?
No, please do the gavel.
All right, well, I
Well
have a couple of forms for you. For two of you. Sarah's gonna.
Thank you, Sarah.
No, she's not, but she said.
Hi, Sarah.